All right, welcome to Defense Diaries. I'm your host, Bob Mata, and Allie's there. I don't know, you done with that phone call?
Yep, but she might
Oh.
call back, but for now, I'm done.
What's up? I'm joined by my beautiful and brilliant host, Allie. What's up, girl?
In these circles, that's what we're in.
Yeah, you don't like the circles. All right, so
I
you
don't know.
guys
Ask
call
the
it. I
people.
kind of love the circles.
I don't not like them.
So it's either this or skirkles. I could go back.
Actually, I
to
like
small.
myself smaller.
Do you? I don't know why. So lovely. All right. I like the circles until I see a vote saying otherwise. It's going to be the circles. All right. So this is our continuing coverage of the Sarah Boone case, the suitcase killer down there in Florida. I'm going to give everybody a real quick summary of the case in case you're not familiar with it. This thing is going to trial imminently. I believe that it's supposed to start on October 7th. So next week, I'm hoping that we can squeeze Sarah Boone in before I have to go down to Delphi, Indiana, and then I'm lost to everybody for a month. I mean, I'll be on the lives, but I won't be with my wife. See, she wasn't even paying attention. She wasn't even. You see what I have to deal with my wife. She didn't even hear that loving gesture I just.
You
gave
did.
to
You
her.
said you weren't going to be with your wife.
And then she does that thing where she repeats it. All right. So if you were not familiar with the case, I'm going to pull up this timeline. Check this thing out. So back in 2020, February of 2020, Sarah Boone and her boyfriend, who is now deceased, Jorge Torres or George Torres, depending on, we'll see how they pronounce it. It should be Jorge. They're being truthful to his heritage. We're having a day, drinking wine, doing puzzles, enjoying themselves. At some point during that evening, things took a strange turn. And according to Sarah Boone, she claims that they started playing adult hide and go seek. That's always fun. Allie and I do that every Friday night. Every Friday night. She zips me up in a suitcase every Friday night. I escape. We have huge laughs.
He's naked, though. He's naked during this
Oh,
game.
Lord, it just got weird. So, any rate, Sarah zips her boyfriend, George or Jorge, into a sleeping bag, or I'm sorry, a suitcase, and stumbles up the stairs to go to bed. And at that point, she claims she wakes up in the morning, looks over, George isn't in bed, and she's panicked. She goes downstairs. She looks around. George, where are you? And then she sees the suitcase in the middle of the floor. She feels it. It's very heavy. And she unzips it and calls 911. That then begins the investigation. The police come over to the house or the apartment. And at that point, they pull her out as they process the scene for approximately 3 hours. I think they finally let her in at some point to get her cigarettes and a Coke or whatever she wanted. And at that point, they then bring her back to the station for an initial interview. Okay. And that is on February 24th. They talk to her and then they release her. She goes home that night, but I think she goes to her ex-husband's house that night, the 25th, but they keep her phone, which is key. And and they had asked her, they said, "Look, we need to look through your phone." She's like, "Fine, go through my phone." And then she comes back on the 25th hoping to pick her phone up because they kept her phone. Now, a couple of things that I want to look at real quick are one, we're going to look at the trigger warning. This video of poor George in the suitcase is it's really really hard to stomach. It really is. So just be warned that it's disturbing to say the least. And if it's not your jam, then maybe take time out, come back in a few minutes. Um, because it is disturbing and it is the smoking gun evidence in this case. I will tell you that for sure. All right, so let's pull this up. I'll try to make it a little bigger. All right, and let's play it.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
Fuck you.
Sarah.
Fuck you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it out.
Sarah. I can't fucking breathe, babe. Where is he?
So he was hiding in the middle of the room.
You shook me.
Sarah.
Apparently.
Sarah.
Zipped himself in there.
It's tricky.
Sarah.
It's tricky. It was hard to do. To zip it all the way.
He figured out how to zip it all the way up, but he couldn't figure out how to zip it.
Sarah, I
unzip
can't breathe,
it.
babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Yeah, I agree. Spitfire.
Reel around.
I don't know about this whole.
Might want to get video
story.
for it extra. Because I got this.
Sarah.
Reel around.
Sarah.
What? Is that a joke?
What, this?
I can't breathe, babe.
Oh. That's
You hide
what
in
I
here
like
while
when
I
you cheat
hide.
on me.
Sarah.
Still can't get out.
I
Fuck
can't
you.
fucking breathe, Sarah.
Yeah.
Spitfire, that's not how we play hide and seek in the States. In the
You
States,
should probably shut the fuck up.
Sarah.
we just close our eyes.
And count. All right,
I know
so
it's true. That's the story, and she's sticking to it, huh?
that is the story, and she is
All right, so
sticking to it.
Spitfire says the story that she is told, she being, what's her name? Sarah.
You have to catch up on this one, babe.
Yeah, is that he was giving her time to hide. I mean,
Yeah, it's unusual. All right, so we're gonna jump back to the timeline here.
yeah, I and just like Susan makes this comment, I definitely agree. I'm just giggling at. I just doesn't make any sense to say we were playing hide and seek and he put himself in there and like hid in the middle of the room. Just a suitcase just appears in the middle of the room, or what Spitfire is saying that she has claimed, which is he got in there to give her time to hide.
Either way, it's total bullshit.
Right, but I do agree
the
it's just
case may
a
be,
prank,
whichever way it goes, there's no way in hell, whether he's the hider or the seeker, that he has zipped the entire suitcase up all the way through from the inside. It's not something that he can do. All right, so now the 25th, she gets into the police station, right? Thinking she's going to pick up her phone. She sits down. They have her in the interrogation room. And this is going to be what the focus of today's motion to suppress is. Allie's like, hey, I need you to find the video. So I did find the second
And
video.
and just a piece of advice to anybody out there, never go pick up your own possessions from the police who claim, "Come in so I can give this back to you." Send a friend, a family member.
Oh, people are asking who made the timeline. Kraken had given me a heads up on my least favorite thing in the world, robots. AI. It's this AI mapping thing that it's pretty awesome. I just started farting with it today because I didn't have time
Farting with it,
to
wow.
have Mandy do it. So it's nice. It's nice. All right. So she gets in, and at that point, they tell her, look, the autopsy came back. Uh, and this thing is taking a turn. So at that point, they tell her that I'm going to read you your rights. So we're going to go through that, just that portion of the video, because today's motion to suppress really focuses on this moment in time. Okay. So it'll be helpful for us to have seen this leading into the hearing today.
Yeah, well, it's crucial. I'm sure they're gonna play it at the hearing as well, but
Probably. We'll get a better view of it. All right. So this is the beginning of it. This is the part that matters.
Just let us know if at any time you need more, okay?
Want to boost the sound a
How
bit?
you sit in the green chair that doesn't move. Appreciate you coming in.
Yes, ma'am.
get my phone.
When I asked about the use in every room, we have a moment.
Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday.
Protocol.
Just like we did yesterday. Remember I read you the rights, your rights? Yeah, so it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right, so you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect, okay.
Hmm.
So this morning we went to his autopsy.
Okay, that's it.
And we were informed of
Babe.
some injuries that he has
What?
by
That's
the
it.
doctor. So I want
Do you have the recording of the phone call? Is that out there in the world?
Which phone call? The
She says
911?
no, she says the same thing I read to you yesterday.
No, that was another time that they had her in. I have not been able to find that. If anybody has a link for that, because they that's when they brought her in initially.
No, she said on the phone call.
Oh, on the phone call? No, because they
Well,
grabbed
rewind
her.
it. Listen,
They
like
grabbed her
2
phone.
minutes. As soon as they sit down.
questions. I need to read them to you, okay?
Sure.
Wait,
All right.
before that,
So
I'll just go to the beginning again.
just let us know if at any time you need more, okay? I'm gonna have you sit in the green chair that doesn't move. Appreciate you coming in.
Yes, ma'am.
You might have been
I
asking.
want to ask about the use in every room. We have a moment.
Sure.
Hmm.
So obviously, he received his autopsy. So
Thank
I'm
you
going
for
to
that.
read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday.
Protocol.
Just like we did yesterday. Remember I read you the rights, your rights? Yeah, so it's the exact same thing, but since I'm
Okay.
asking you follow-up
My bad. She
questions,
said
I need to read them to
protocol,
you, okay?
and I thought she said
All right,
phone call.
so you have the
No,
right to
but-
remain silent.
But you're right in the sense that they didn't bring her back to the station yet. Now that people are saying it, I remember they actually had the first interview with her in I'm assuming one of the squad cars at the residence. They talked to her for a while. That's when they get her phone. Okay. So do you feel sufficient that we saw enough of that?
Yeah, so let's tell people.
Well, here, like, can I just read through these motions real quick?
Yeah,
They're
that'll
short.
tell people. That'll give them the answers anyway.
Okay,
So,
cool.
yeah.
All right. All right. Let me get these up real quick. We're up against it. We're at 145. Mandy, can you keep an eye on the stream to make sure court doesn't start? Because I want to be timely getting over there. All right. Okay, let's go. All right. So this is now I was, of course, I got this from the only place to get your documents, which is Seeking Justice Discord. This is the only one I could find. Now it's amended, which means that there was another one that had been filed previously in terms of a motion to suppress, and at some point they amended it. I have a feeling that it was either done by one of her 8 other attorneys or by Sarah Pro Se herself. This attorney came in and amended it. Allison, I can tell you, I know you haven't read it yet, but you're going to be furious because there is not one bit of case law cited anywhere in this 5 pages. All right, so it's an amended motion to suppress defendant's statement at OCSO. So comes now the defendant, blah, 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 by and through the 5th and 6th Amendments of the United States Constitution, Article 1, Section 9 of the Florida Constitution, and respectfully amends this motion, moving the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office. In support thereof, states as follows. 1, the defendant, Sarah Boone, is charged by way of information with a single count of second-degree murder. That on or about February 24th, 2020, the defendant called 911 in response to finding her boyfriend, Jorge Torres, deceased. Paragraph 3, Deputy Kayla Rodriguez of the Orange County Sheriff's Office arrived on scene with her body cam activated. Upon arrival, Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her superiors and secured the scene. Paragraph 4, sometime later, homicide investigators Chelsea Conley, aka Chelsea Copsel, and Scott Lowen arrived. These 2 investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at the OCSO the next day. Paragraph 5, the defendant was ordered to remain on scene. Hold on, I got to get my scrolling ready. While the OCSO conducted their investigation, as ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. At some point in paragraph 6, the defendant was told to get into an unmarked vehicle with Detective Copsel and Detective Lowen. Once inside, Detective Copsel recorded an interrogation with the defendant after partially reading her Miranda rights, in parentheticals, omitting the final question. The defendant was advised that this recorded interrogation was routine protocol, an official procedure for any death investigation. Paragraph 7, during the investigation, Detective Copsel asked to see the defendant's phone. The defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and instructed the defendant to unlock it. The defendant complied with the demands of the lead investigator. You see how that's carefully crafted. They use the defense counsel used words like demands, complied. All right, paragraph 8. After Detective Copsel had the defendant's phone for a period of time, she came back and told the defendant that she was taking her phone. So she didn't ask her, apparently, according to the defense. Detective Copsel asked the defendant to sign a form releasing it to the OCSO for further investigation. So there you go. So again, here's careful wording by the defense. The defendant acquiesced to authority and signed the form.
And that's legal jargon. That's precisely the language you're supposed to use that, you know, when someone just sort of gives in to a show of authority by the police is not an affirmative waiver. So this being said, like what you're reading right now, we obviously would have needed to move on to a different portion of, because we just dealt with the statements, not the phone.
Right. Well, I don't think they're trying to suppress the phone itself. Like the
Oh.
phone would have been the video. I think that they've done that and that was denied. They definitely already. I think there's been the hearing to try to keep the video out. The video is the worst.
That was
I
found
mean,
on the phone?
Yeah, the thing that we just watched. She didn't know it was there. Like, you remember when you and I were listening to this when we were, I don't know where we were driving. It was a long drive somewhere, and we were just listening to the interrogation of her. And, she was all cocksure at first, like, oh, yeah, go look at the phone. There's nothing on the phone. And they're like, oh, really? Well, here, check this video out. And like, boom. All right. So, paragraph 9, the defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Paragraph 10, later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Copesel on her cell phone to express her concern that the detective was not being truthful about law enforcement's motives as it relates to the defendant. The defendant told the detective she believed that they were trying to trick her and being sneaky about something. Paragraph 11, being sneaky about something. Is that like Allison, like if she were writing a memo of law or something, she'd for like an hour, she'd be trying to, she's like, okay, well, I'm not going to write, they're being sneaky. What's something better that I can write?
I'd spend an
other than-
hour looking for like deceitful or
Yeah,
trickery. I mean, we
man,
use trickery.
chicanery, bamboozled, run amok, led astray. 11, the detective assured the defendant they were not trying to trick or implicate her, but that the following day, the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. The detective explained that the reason for the change in plans was because she was pregnant and not feeling well. The old, I'm pregnant and not feeling well trick. Paragraph 12. The next day, February 25th of 2020, the defendant arrived at the OC SO to retrieve her phone and had questions about this tragic event. Upon information and belief, a judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's department. And
Or the
that
phone
is
they
not,
already searched.
but with her consent. Right. So I bet that is not an uncommon move for them to find something on a consent search and then to run in order to just cover their asses
And
to
to do a
secure a search
more
warrant.
in-depth analysis as well.
For sure.
Right.
Yeah, they can get all the metadata. They could really dig into the phone. They could probably extract it. Like, I don't know without the warrant if an extraction would have been allowable at that point. You know what I mean?
It depends on what she signed. Yeah.
Yeah. All right. So 13, while still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs to an interrogation room or into an interrogation room. Detective Lowen wore his firearm on his waist during the entire event. Again, trying to show that she would not have felt that she could have left the building, right? A custodial interrogation ensued. Immediately after the interrogation, the defendant was formally arrested and charged with the offense above. 14, this approximate 2-hour interrogation was recorded. 15, the initial dialogue between Detective Copesel and Sarah Boone. Detective, I'm going to have you sit in this green chair. Detective, appreciate you coming in. Sarah Boone, yes, ma'am. I wanted to ask you about these whenever you have a moment. Referring to her written notes with questions. We know Sarah Boone loves to write notes. She's a big note gal. What's up, J-Bo? J-Bo's living in the glory of a game 1 victory of the 3-game wild card series between the Mets and that suckbag team that they're going to take out. Is it tonight, Jay? Is game 2 tonight? But they're all there. They're all in the same spot. So, detective, sure. Detective, so obviously we received his autopsy. Detective, so I'm going to read you your rights because underlined, bolded, we have to talk about that. Detective, and we're not done talking about the incident. Detective, underlined and bolded, we just have to do it. Sarah Boone, just like we did yesterday. Sarah Boone, normal protocol. Detective, just like we did yesterday. Detective, remember I read you your rights? Detective, yeah, it's the same exact thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Detective, so you have the right to remain silent. Anything you say may be used against you in a court of law. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone, no. Detective, bold for emphasis. And you do understand what I just read to you? Sarah Boone, yes. Detective, perfect. Okay. Detective, so this morning we went to his autopsy. We were informed of some injuries that he had by the doctor. Defendant, where? Detective. So he's got scratch marks on his back. Paragraph 16, the interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested. 17, the detective read the defendant her Miranda rights directly from the printed card of the OCSO. The detective omitted the final question printed on the standardized Miranda card of the Orange County Sheriff's Office. 18, the detective omitted the same Miranda rights question that she omitted the day prior or the day before. The omitted final Miranda question is, having these rights in mind, do you wish to talk to us now? So 20, the defense is yet to receive a true and accurate copy of the Miranda rights card from the Orange County Sheriff's Office. 21, upon information and belief, it would look something like this. So you guys can see that. Then you've got the actual waiver down here. So there's the waiver. So 22, based on all the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely and voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. So cites no law, again, cites the 5th, 6th, and the Florida Constitution. All right. So there's that guy. Let me take a peek real quick over at the courtroom. See what's up over there. Where are we at? Okay. All right. Looks like we're not live yet. 2 minutes, 31 seconds. It says it's going to fire up. All right. So let's go back to our documents. Okay, so this is the state's memo in response. It's short. All right. Comes now the state of Florida by and through the undersigned ASA. One, Deputy Kayla Rodriguez, in response to a 911 call made by the defendant shortly before 1 p.m. on February 24, 2020, responded to the defendant's residence. Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. There are 3 recordings. One begins at approximately 1:08 p.m. and lasts 13 minutes and 32 seconds. The next starts at approximately 1:22 p.m. and lasts 4 minutes and 56 seconds. The final one starts at approximately 1:30 p.m. and lasts 5 minutes and 30 seconds. At no time was the defendant in anything that resembles custody for Miranda purposes, Ramirez v. State.
I thought they might argue that, but
Who might?
the state, but I don't know if that door was shut and locked. She looked in custody to me.
She's definitely in custody, but like they're talking about. See, that's the thing. This is the day of. This is the day when she's in the car. So this isn't at the station. Do you understand
Well,
what I'm
she's
saying?
locked in the back of a police car.
Right. Right. And they're not letting her go into the apartment, but that doesn't mean she can't leave the scene. So
Yeah,
at no
but if
time,
they're limiting her movement, like things like that, that definitely says you're in custody. You asked to go in or to leave, which I don't know, maybe we'll see. She asked to go somewhere else and they wouldn't let her. But the denial of letting her go somewhere, although if they were exercising a warrant, all right,
all right,
keep going.
let me read through this so I can switch over the thing. Then you can talk all you want. The Ramirez case outlines the famous 4-factor test. A, the manner in which the police summon the suspect for questioning. B, the purpose, place, and manner of the interrogation. C, the extent to which the suspect is confronted with evidence of his or her guilt. And D, whether the suspect is informed that he or she is free to leave the place of the questioning. See, to me, what's going on is the state's trying to play a little 3-card Monty here. They're talking about the first interrogation on the day prior, whereas the defense is talking about the one that we just watched. All right, so 5, while Deputy Rodriguez would not let the defendant enter the crime scene, the defendant's home to retrieve soda or cigarettes, the defendant was not in custody, State v. Recone. 6, the deputy was a first responder trying to gather preliminary information about what might have happened. The defendant was spoken to on her porch and sidewalk area just outside of her home. She was not confronted with any evidence because at that time, there was nothing to confront her with. The defendant was informed that she was not free to leave the area due to the investigation, but the restraint on her freedom of movement never resembled custodial arrest. 7, just under 4 hours later, she was interviewed by detectives Copesel and Lowen inside an unmarked car on the scene. Although under both Ramirez and Rincon, this is not custody for the purposes of Miranda, she was given her Miranda warnings. Bullshit. That's custody to me. 8, for the reasons outlined in the state's response to the defendant's motion to suppress statements at the OCSO, the Miranda warnings were not defective, and her waiver of Miranda rights was voluntary, and her statement was voluntary. Any motion to suppress on those statements should not be granted. So there you go. That's that. Okay.
Well,
All right. I'm going to pull it up because we in court, it looks like.
Well, I did find a case that dealt with this precise issue, although, so when Bob and I were talking about this initially, I was like, well, if they give all the other warnings, and again, like here, she asked, do you understand? And the answer was yes. Did anyone threaten you to talk to us? And she said no. I think they might find that's enough and that they don't need to say the magic words. Now that you understand, are you still willing to talk to us? Although that language has been, the focus of some cases.
Sorry. Stop talking because of me.
No, I was
Mandy,
done.
can you get this thing switched out so that it's blocking the long crime thing? If possible. Or do you know how to do it, babe?
Oh wait, sorry, I was looking at the case.
Yeah, I think we need a different frame, probably.
You want to move us down? What do you want to do? Oh,
No,
cover them.
we need to see on Jay's thing, he could just move a little thing on top of that. That's one of the faults. It's one of the reasons he hates StreamYard.
Yeah, that's all I got.
That's
Whoops, sorry.
whoop whoop. All right, let me see. Let me try some different stuff here. Let's see. Oh, all right. Now flip us over to the other side now.
Okay.
If that works. There we go.
We were bigger before, though.
What do you mean?
Huh.
No. Like us, like our pictures were bigger. There you go.
Okay.
It's a little bigger. All right. Okay, so spit, babe. This is your chance to spit.
So I forget what I was saying.
Well, it has to be something about the fact. So
the back seat of the car, I just started to look at that, but this is like a 1990 defendant when stopped for traffic violation was not in custody for Miranda purposes when questioned in the back of a squad car. But who knows what that was based on? Let me see.
Well,
The defendant was not under a custodial interrogation for Miranda purposes when he made statements while in the front seat of a squad car. So they seem to be making a distinction there. Let's see what they said.
All right. So, but here's what the question is, because in both situations, they did read her Miranda. They didn't read the waiver.
Right. That's where I was starting with. And I'm saying that,
Stick with that.
Okay. Well, the cases do focus on that, but then the ones that I've read, like here's the one in Florida that I read. So prior to trial, The parties discussed admissibility of the defendant's statement. The defendant argued that the defendant asserted his right against self-incrimination at the very beginning of the interview. So they kind of end up focusing on that. The state proffered that the detective's testimony concerning what took place prior to the statements. At no time prior to the recorded statement did the defendant say he was not going to answer any questions or that he wanted an attorney. The defendant was not threatened and never indicated that he did not want to answer questions. The detective stopped the interview when the defendant said he'd rather have a lawyer, which is kind of equivocal. Like, we're always telling people, you can't be like, I think I might need a lawyer, maybe I need a lawyer. The defendant's statement was played for the court. After listening to the beginning of the recorded statement, the trial court found that it did not reflect whether the defendant actually waived his rights. So the court ordered the state to recall the detective for additional proffer. The detective testified that he read the warnings before turning on the tape. The defendant answered all questions and never said he was not going to speak to the officer. The detective signed the back of the card, and then the tape was turned on. When the court asked the detective if any conversation occurred before the tape was turned on, the prosecutor handed the detective a document. Before the detective could respond, shady, defense counsel objected and asked to see the document. The prosecutor stated that it was a witness statement from one of the officers, indicating that the detective read Miranda to Womack, who stated he understood and signed the rights card. At that point, the defense counsel moved for a mistrial. Okay, blah, 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 blah. Sorry. Independent recollection. The defendant told him he understood his Miranda rights. The detective always reads directly from the card and asks the defendant if he understood each of the rights in all interrogations. Defense counsel declined to further question the detective, but again moved for a mistrial, arguing that although the detective asked if he understood, he never asked, having read those rights and understanding those rights, do you wish to talk to me? The trial court found the state's initial proffer was insufficient to establish the defendant had waived his rights, but found that the detective credible and that the defendant waived those rights. The court found the defendant's initial statement equivocal, meaning I'd rather have a lawyer. The court also found that although the prosecutor's conduct was improper, it did not warrant a mistrial. So they went on to say that trial court found the detective to be credible during the proffer, and at trial, the detective testified that the defendant understood and waived his rights. These findings are supported by competent, substantial evidence. I mean, sure. The more difficult argument is whether defendant's comments in the beginning. So then that's what I'm saying. Like, I haven't found a case that really hones in on that issue. Although there was the one in Illinois, it's also a little bit strange, but so here they said, for the following reasons, we reject the defendant's claim that it is arguable that appellate counsel was deficient for failing to raise the issue of the validity of his Miranda on appeal. First, the defendant's argument was he was not asked if he wished to waive his rights. We note that the detective clearly advised the defendant before they were able to talk to him and explain things or answer any of his questions that they had to give him, quote, something called your rights. The detective continued, okay, quote, okay, question mark. It is often known as your Miranda rights. I am going to read you your Miranda rights. I am going to read your Miranda rights to you. Okay. So now this is the court's words after this. Therefore, though not required, the detective did in fact ask permission to read defendant his Miranda rights prior to questioning him, which was not the freaking argument that the defendant made, right? Like he said, they didn't ask me if I was waiving them. So in any event, then they just go on to talk about how the waiver wasn't in writing and that it doesn't need to be in writing. Um, and the audio tape clearly reveals that the detective read each of the rights of the defendant and then specifically asked whether he understood each right, to which he responded yes. Third, and I don't think we have this here, the defendant had prior experience with law enforcement and was on parole at the time he was questioned. Thus, the defendant's background and experience supports the conclusion that he knowingly and intelligently waived his Miranda rights. So I pull these cases because it does show that this language here, whether they give that last little bit of language, is something that the courts consider. Although every case that I've read thus far, and there are more I haven't finished, um, you
Because
know,
I think that the knowingly part is established as far as the state's concerned. The voluntarily is the issue here, whether or not she actually waived.
whether she waived. Right, that's the
Right.
question. And I feel like the court's gonna be like, just like this court did here, like, they gave all the warnings. She said she understood. And, like, even without that last little piece here, I feel like they'll still find that it was okay. But this was an Illinois case. That the other case that I was reading was a Florida case. Um, I did find another case where they
Good
specifically
question, Kraken.
what?
Just like do the shit right. Read the whole goddamn card. Like
Right.
why be tricky, you know?
Exactly, exactly.
Like that's the thing. You know, like that like when they pull that shit, it makes you think that they're up to no good. You know, because of the way it went is, has anyone threatened you or promised you anything to get you to talk to me, Sarah Boone? No, detective. And do you understand what I just read to you? So okay, so there's knowingly. Sarah Boone says yes. Detective says perfect. Okay. So this morning, and then she goes right into it. So
Right.
I think there's a decent argument that she didn't knowingly waive, or voluntarily waive. Like
Right,
so,
except it's implied by the fact that she continued to talk after she understood those, you know, those warnings.
yeah, yeah. I mean, that's ultimately be like what the judge is gonna, because the judge is not gonna keep that shit out. I don't think. I'd be surprised if the judge ruled that way. As irritated as he is with her in general.
So in this case, the one I'm reading now, which is also an Illinois 2022 case. Now, in this one, he also didn't say the words, "Do you understand?" So he didn't do both of those things, you know? Um, and it says that the trial court granted the defendant's motion to suppress the statements. In its oral findings, the court initially noted that the state's sole argument in its written response to the motion to suppress was the defendant was not in custody when he was questioned. Whether the defendant was in custody was a question of fact, requiring consideration of the various factors, but ultimately coming down to the totality of the circumstances. So,
Yeah, I think the fact that I think it's gonna help the state substantially, the fact that they were read to her the prior day, right? And so theoretically, she had that evening to go home and call people like us. You know, we get those calls all the time, you know, where cops have made some kind of initial contact, and then they're like, "What should we do?" They want me to come into the police station, and then typically Allie will say, "Well, you know, pay me some
so
money to come in and sit in with you if you want to go," or you just tell them to pound sand. You have no obligation to go there. But like the number one rule always is shut the fuck up. You don't talk to the cops without a lawyer, period. I don't care if you're innocent, you're guilty, doesn't matter. You never talk to the cops without a lawyer present.
so in this case, the one from Illinois that I'm reading, the court granted the motion to suppress, so the state filed an appeal. So whoever is appealing, it's harder for them. So in this case, the trial court's ruling was affirmed, and the appellate court found that the statements, he was in custody when he made them, and the circumstances surrounding the waiver was not knowing and intelligent. So I want to go down to the custodial aspect here because it's very similar to what It's what we have here. So the defendant had initiated the investigation by voluntarily reporting himself, and his encounter with Woods was non-custodial. The court recounted. That's the initial. However, after driving defendant to the sheriff's office, Greg was not allowed into any part of the facility. The interview room was small and windowless. Although it was not locked, the defendant was never told that it was not locked. And Quick stated the defendant might not have been able to exit the building anyway. Once inside the room, the defendant was not told, as neither was she, that he was free to leave. The defendant was seated in a corner, and Quick sat down between the defendant and the door. He was in plain clothes but armed with his gun, the other police equipment. Defendant was left alone in the room for 10 minutes before detectives returned. The mood of the interview was not coercive. Indeed, Quick was friendly and non-confrontational. The court continued. The mental makeup of defendant, was that he was there to confess his sins. He had been directed to contact the police by his pastor. So the evidence established that the defendant had been a member of his congregation for some period of time, and the reasonable inference is that he took comfort and solace from direction provided by his pastor. Hey, I hear my voice.
That was you.
The court's conclusion from the backstory regarding his religious affiliation, his longevity with the congregation, and the pastor, and the fact that he contacted the police to confess his sins or transgressions is that he was in a vulnerable state when he was at the sheriff's office. Under the totality of the circumstances, a reasonable person would have considered himself to be in custody and not free to leave. The court then added, in reading the Miranda form, Quick referred to the fact that some people might consider the environment as custodial. Neither detective told the defendant that he was free to leave. Moreover, the detectives were clearly seeking incriminating information. The court next addressed whether the defendant knowingly and voluntarily waived his rights. Okay, so this is a juvenile, so they were using a juvenile form. So this also has differences there. The interview was conducted without coercive tactics. Further, while Detective Quick may have minimalized the involvement of the sheriff's office and, as argued by the defendant, couched the interview in terms of just three guys talking, he did not do so impermissibly. Thus, the real issue in this case ultimately turned on whether defendant knowingly waived his Miranda rights. The court noted that under the governing case law, a knowing waiver requires the defendant have a basic understanding. There's no explicit authority that the defendant must be asked whether he understands each right. And the court had not found any Illinois appellate authority that holds there is an intelligent waiver without an acknowledgement by the defendant that he understands his rights. So there we go. That one's different here too. I think it's not enough because they did say, do you understand the rights? And did anyone threaten you to talk to us? The common thread of the cases was that this acknowledgement is necessary because understanding is a prerequisite to a knowing waiver. I mean, I guess the same argument can be made that the question was necessary, meaning, and do you still want to speak to us? Is a prerequisite to waiving. But
there she is in all her glory. Oh, we got to give a shout out to our girl Mandy, back in the fold. She's back, baby. Welcome back, Mandy. We all missed you. It's good to see you in the chat. Oh, look, they gave her a full pen. She's got a full pen. That's big. It's big. They usually just give you the ink cartridge, little flimsy thing.
Huh.
Yeah, if you're late to the game today, with trial is looming. Trial is supposed to start next week. Today, there is a motion that has been filed by the defense wherein they are seeking to suppress all of Sarah Boone's statements that she made in her 2+ hour interrogation on the 25th of February. The grounds are failure to waive her Miranda rights. She was clearly read the rights. The question that's going to be at issue is whether or not she intelligently and voluntarily waived them. And don't worry, I don't have it muted. They just haven't turned the sound on. They won't turn it on. The judge will be the guy. He'll be the one. Yo, what's up, Steve-O? Steve's in the house. Got all the beautiful humans in here today. Got all of them. All of them in here. Missed you guys. Missed you. Still only had 50 people in last night. Everybody must have been watching that just can't miss TV with the vice presidential debate, right? Last night, instead of watching Bill and I. You guys are giving Bill a complex. I'm telling you that right now. London was spectacular, CJ. We loved it. Allison, if something amiss happened here, what would you be saying if we were in London?
Oh, that's proper rank.
You forgot the last part, isn't it?
Isn't it?
Isn't it?
Isn't it?
Oh, that's proper rank now, isn't it?
Yeah, isn't it? Jeez.
Yeah, it's great. It was like Allie was on repeat with that.
Well, our daughter
That's
found
fair.
this.
That's fair, Chelsea. Catching up on the bear is always okay. That's one of the few things that you're cool to skip alive is if you're watching the bear. I think I still have not watched the full final episode of the most recent season of the bear. I think I'm like halfway through. I'm like dying to see the review. Like I haven't seen the review. No spoilers in the chat. Don Burke. What's up, girl? Katie, Jacqueline, everybody's here. All the peoples. Christine. I know you love Bill, but you're always there. Christine's always in the house. What's up, Brooklyn? Good to see you. Missed you. Look at that. Look at Mandy. Just seeing Mandy with the little wrench by her. It's good stuff. It's good stuff. All's right with the world. All's right with the world. We had a glorious time though, Katie. We really did. It was I'm like in love with that town. Not a cheap town. Not a town if you're looking to not spend much money. It is not a cheap place to go. That's for sure. Shit, our play was Allie and I, we took the girls to go see Stranger Things at in Leicester Square, the West End, Phoenix Theater. It was amazing. It's the best play I've ever seen, like in terms of the special effects, the way they incorporated it was like next level. It was like you felt like you were in a movie. It was unbelievable the amount of special effects they had. It was insane. And it was a really cool thing because it was a prequel. It predated. It's how everything that happened prior to the Stranger Things that we know. So this is like, I think it was like Hopper as a kid, right? Like the sheriff.
Yeah.
He was a kid when he was in high school. So it was like a lot of the main characters when they were in high school, like Winona Ryder's character, who was feisty back then in high school too. Yeah. Yeah. And just by the way, if anybody is going to London to the Crime Con next year, I think Bill and I are doing like a full blown big room Gacy thing out there, which I think will be pretty awesome. Make sure you're using the promo code DEFENSE, all caps. Like we had not one person use our code, which didn't help us. You know, I mean, it did not help us. It's like it was my fault because I was not promoting it enough. I'm going to promote it a lot because it really helps us. It lets the con know. Plus, if we get enough, they pay for our hotel rooms for the 2 nights, which is nice.
So here's a 2023 case in Illinois that says defendant's waiver of his Miranda rights was not rendered invalid due to the detective's failure to ask him directly before reading him his rights, whether he wanted a lawyer or whether he wanted to talk to the detectives before detectives began questioning him about the shooting as required under, so he was also less than 18.
Yeah, Spitfire. I can't wait to get over to Ireland and Scotland both. They're both motherlands for me. Got the Scottish, the Irish, and the Cherokee. Cherokee is I'm most excited about that little piece right there. Anja, the food, I mean, the fish and chips were fire. They were delicious. But like we didn't do like a foodie type meal because like none of my girls that were with me are foodies. So it would have been I complained not bitterly to Allison when we got back. I'm like, you gotta up your foodie game because like I want to eat at some like world class restaurants with some amazing chefs. Ah, what's up, Amber? Good to see you in here hanging. What's up, Greenie? Simply Bell, Afton, all the people's hanging. Here's the lawyer explaining. So there's no way we're going to win this motion. You understand that, right? Don't try to fire me when we lose this motion.
I think it's more likely that she was in custody, um, than that failure to ask that last question is gonna be an issue, but
Wait, you think that they're gonna like harp on the whether
no, I
or
think
not
that
it's
she's in
custodial?
custody. I think they're gonna find that she was in custody.
Yeah,
Right.
and
But I
like
don't think the failure to leave out that, that last question.
well, because I think that the concept of that she wasn't right or Miranda is mooted because she was.
Well, I
The
thought
question was is whether or not she
specific
waived.
issue was whether they said the words, "Now that you understand those rights, do you still wish to speak to me?"
Right, that's the knowing waiver,
Right.
right? So it's like she was obviously given her rights, so she couldn't claim that she didn't intelligently understand them because they asked if she understood them and she said yes. So the question is did she waive them then? Because she did in the second one, she did go right into questioning. She didn't say, okay, knowing that you know them. Oh, what's up, Sean?
I gotta switch to Florida law because Illinois is pretty clear even when dealing with a juvenile that they
Exactly. There's no
that
question, Sean.
that there's never been a case that has invalidated a custodial statement on the basis of the failure to ask that, you know, "Do you still wanna talk to me?"
Sean, we need to collab, dude, like with the quickness. I don't know what's taken either one of us so long to collab. I think didn't I come on for a hot minute with the rancher case with you? I think I jumped on. I can't remember. I might have just been in chat. It's all a blur these days, but let's make that right. Got to get a collab going. If y'all have not subbed over to Sean's channel of Potentially Criminal, it's great. Fellow lawyer, brilliant guy, funny guy, really funny guy. He's got a great channel over there. And Sean gets into all kinds of shit. Like he'll get into like Sean's way braver than I am. Like he'll get into some political shit. I don't touch it with a 100-foot pole. Sean don't give a fuck. He just goes in. If he wants to chat about it, he's chatting. He is chatting big time.
I have, like, a little
I was messing around on Sean's channel and he was building a plane model one time. It was awesome. Like he had like an actual, like a model plane that he was building. It was cool. Like he does that under like a different, like that, like he didn't advertise it. It was you're coming to watch some true crime. He advertised it as like, you're coming to watch my ass build a killer model. So it was cool. I thought it was really uh, potentially criminal mods. Can you please throw his link up for us in here, please? I'd appreciate that. Yeah, because he's right there with me. I think he's at 23.4. He's at 23.4 subs, and all well deserved. Here's Kranick. Kranick, he's got a little bit of. Woo! All right. Might be cranking the sound booster.
Cork, I'm ready when you are.
That's right. All right, the clerk's mic.
William J. for the state.
James Owens for Sarah Boone.
Oh, Jesus, the mic suck.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah
That-
Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the
That's
motion
right.
to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m. Defendant's
shit.
second amended motion to
Oh,
suppress
shit.
defendant statements at OCSO.
We were live in our
State, have
defense.
you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Thanks for the love,
Okay.
Joanne.
Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card?
Yeah, if you look
I think you could now
back,
boost it now that the judge isn't talking.
if you look in the very back,
Okay.
you see the Miranda card, the last page, and the next to the last page.
Yeah, there's no need to.
Yeah, he's just not on a mic
For
right now.
authenticity. We still
All
have
right.
our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell what you can?
Yes.
All right, so that saves us some bullshit witnesses. They're going to agree to the authenticity of the record so that the custodial records doesn't need to be called for foundation.
I also have reviewed the 2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification of his DVD, courtesy copy, body worn camera.
Come on, dude. This
They're
guy's over
putting
there
in the
leaning
body.
on the bench. Look at
They're
this guy.
putting, they're putting in the body worn camera.
Yeah, I heard that. That was the only part that I heard was body worn.
And I have reviewed all of those in advance of today's hearing.
Pretty comfortable in that courtroom there, huh?
Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1.
He marks it A. He's like, I want it to be 1.
Get into a huge semantical argument. Sarah's just sitting there thinking, oh my God, I'm so glad I don't have to talk.
Is that her?
Yeah, right there.
I thought she had long hair last
She
time.
got the butter whipped. That's a prison cut. Oh, please talk into the mic.
Good afternoon, ma'am.
Well.
Could you state your full name for the record and spell it for us?
It's Chelsea Castle.
Oh, yeah.
Helsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Scott Lowen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I've already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe.
And real quick, just so y'all know, in this type of motion, when it's a defense motion for suppression, in this particular circumstance, it is the burden of the state. Okay, so the state has the burden of showing that it was knowing and voluntary. So that's why, if you're wondering why the defense didn't go first, even though it's a defense motion, that's because it is the state's burden.
I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, it's not.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. And, so I don't think I really touched it until after I had talked to her about going through it.
Remember that? All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house.
Prior to that, had she been detained and requested not to leave the scene?
One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
It But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be on the back of your building where people are not free to come in and out of without a swipe card.
Yeah. That probably doesn't make sense.
All right, here's the deal. I'm going to try to switch over to Court TV. Let's see what the deal is over there. Got it in good authority. It's better. It sounds better. Okay. Let's see.
Got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be on the back of your building where people are not free to come in and out of without a swipe card.
Yeah. That probably doesn't make sense.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
In your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report.
Yeah, it sounds the
and
exact same.
I have looked at some policies, but they were
All right, we're going to switch back over
All right.
here.
Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
In your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or
And-
maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know, there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question. Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Right. Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance. Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other.
So is there some sort of constitutional violation
Our
for not
argument
following policy? I don't think so.
is that she did not waive her rights.
But
Remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On
I don't know.
February 24th
Worse
or on
is the
February 25th?
argument.
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person. Interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her,
I was muted, of course. So what I was saying is the judge has basically already ruled on this motion. He said that none of the case law says that no law enforcement officer has to read that waiver language. So, I mean, and he's trying to make an argument like we know where the judge's hat is right now, and it's on the bed.
I mean, he could have found at least some case law. I don't know why he did that. And even I found some stuff in Florida that at least focused on that language specifically.
I mean, I heard you read some that kind of agreed with it. So, like,
Well,
he ain't feeling.
at least showed that it was something relevant to the court's consideration. It sounds like this lawyer hasn't even given the judge any reason to believe there's anything about that language at all that's relevant to his analysis about whether or not.
Yeah, and you know what the lesson for this lawyer is? Good old James Owen. Maybe put some fucking case law in your motion, bro. Like,
Or at least
like
provide
what,
it
like
to the court.
something. Give a citation, even if you're not going to quote any cases. Well, yeah, or give the court some courtesy copies of some cases that they think support your position. It's got nothing. He's just making an argument.
her not to give
Thanks,
that
Don.
question goes to the totality of the circumstances as to whether or not my client, Sarah Boone,
Waived.
actually waived her right to remain silent.
Right,
If she
that's-
understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a
True.
motion to suppress, just like it would be in a traffic stop under Wren versus United States. What
True.
matters is objectively what was spoken to the defendant.
And the
And
impact
I
it
would
had.
ask that we honor the local administrative order and call people by their surnames and not their first names. What matters
Snarky.
is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple.
Say something.
Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take
He
any
switched back to
technique
coerced.
or a non-technique, something that you use or don't
Come on, buddy.
use to
Get your head out of your
establish
ass.
whether or not it was coerced or not. The fact that she didn't read Do you understand the rights? Do you understand these rights, which is the form, the Miranda warning
She did
form?
read, he did read
Do
that
you
one.
wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you.
He's like, I'm going to let him make a
You're
record
referring
for,
about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her
as
in your
written.
squad car?
All 9 questions is.
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read from. Continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the, in reference to the policy, yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that
Okay.
there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
She had pregnancy brain.
Mhm.
Mm-hmm.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines. Yeah.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few years.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Long was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the 3 issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
Right.
I think my response.
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided
On the
prior
20th,
to that.
Yeah.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on 2 separate occasions. She wasn't in custodial
Ted Cruz, he ain't buying it. I'm telling you that right now. He ain't buying it.
interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection is sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Videotapes.
As to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to
That
you
we just objected to.
before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
That is relevant.
Overruled.
Yes.
Okay. And would it be fair to say
Incriminating
that you
information.
wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
Trying to gather
And
incriminating.
you also wanted to question her about the 2 videotapes that you had found on the phone.
Oh my God! Quit calling them
Overruled.
videotapes.
Yes.
And you agree, in your opinion,
Your Honor, I'm not a cat.
the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection, relevance.
Overruled.
He's like, I just want this over.
Videos- I'm sorry. Repeat your question one more time.
Yay! Thanks, Mag.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, relevance.
Sustained.
Sustained. Come on, buddy. You're close.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have
But I did hear through the grapevine your motion is hot garbage.
you sit in the green chair?
Objection, best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay.
It's
Do
cross
you agree,
Ask her questions. Come on. You directed her
prior
where
to reading Miranda,
All right, what would you ask her?
You directed her where to sit. You did not tell her she was free to leave.
But
Did
those
you-
are all custodial questions, and they've already they've acquiesced that she was.
I don't, then what the hell was the thing that he filed the motion that you read?
I don't like. That's what I was telling you. We were going through the motion. I'm like, I don't know why he's like sniveling about custody, because clearly it was custodial, especially on the 25th. 24th may be arguable, but
Right.
25th, like,
Well, then I would just
me,
get
this
to the
whole
point that he
thing-
already made, that you did not ask her if she waived, and she never said she was willing. She never specifically, explicitly said to you that she wanted to talk to you.
right. And like, to me, his argument that he was trying to make is essentially like, well, I know that this isn't a probable cause.
But he's trying to establish that they already determined that she was
They
guilty,
determined she was guilty,
and
they
they were
trying
trying to get more evidence. That's why I said, just ask, were you trying to get an incriminating statement? Yes, I
Right.
was.
That's it. Like, that's all he needed to ask. He wouldn't tie it up like that. It was driving me nuts.
that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that. referring to the autopsy.
Objection by Stebbins.
Sustained.
And we had to talk about the videotapes that you found on her phone.
Do you recall making some comments to her prior to reading her the rights?
Objection by Stebbins.
Overruled.
Sarah Boone is sitting here like honest to God, she's thinking I would
Need to
be
fire him.
doing so much better at this argument than this guy. This guy is the biggest piece of shit. She's going to try to fire this guy after this hearing. Watch.
No, he's doing the best he can.
That what? He didn't tie together the argument. Like,
The
it's a
judge
simple
knows what he was getting
argument.
at.
Like,
The judge knows what
keeps
he's
putting him
getting at.
down on the PC. He's like, I'm not really trying to get at PC, trying to show the totality of the circumstances in that they had already decided. They had already decided that they were arresting her.
And the reason
charging
that
her.
this is important is because, but again, it already goes, if they're agreeing that it was custodial interrogation, then it doesn't matter also. But, the fact that they're not just having a friendly conversation, there the subjective intent does matter, that they're trying to gather more evidence to firm up her guilt, meaning incriminating statements.
Yes.
Is it the policy of the Orange County Sheriff's Department
boy.
to make any statements to them about the interrogation prior to reading Miranda?
Objection relevance.
Overruled.
One more time.
Yeah, because the question wasn't good.
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told
How long?
to ask or not to ask
6 years.
any statements or any questions prior to reading Miranda relating to them talking to you?
Objection relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
Had to have. Now you can use that. But what you said is you had to have, didn't you?
Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting
You'd never asked
question number
her.
9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have
Oh, bye, Bobby. He'll be back. He'll realize it. There he is. I hear him coming. There he is.
Oh, hi.
Hi.
Hey.
Hey.
Where's the shit?
Well, when you disappeared, it disappeared.
Oh, sorry. That was some bullshit.
Sort of like this hearing.
Guess what? You didn't miss anything. A lot of hemming, hawing,
Struggling,
grandstanding.
trying to get some questions out. What am I going to ask? How am I going to ask it? The fuck am I supposed to do now? He's not letting me ask anything. I'm starting to sweat.
Do you like apples?
I don't know. Is he getting that standardized form in? I mean, like, he's just not.
I would rate this this cross-examination here like
Four.
this.
Wonderful. Bravo. I loved that. Oh, it was great. Well, it was pretty good. Well, it wasn't bad. Well, there were parts of it that weren't very good, though. It could have been a lot better. I didn't really like it. It was pretty terrible. It was bad. It was awful. It was terrible. Hey, boo! Boo!
Stadler and Waldorf know. They know. These guys are always on point. Oh, Chrissy, thank you. Thank you so much for the support.
This is all legal argument. This is nonsense.
Hopefully he makes it right there to the side of her mic, which we can't hear either.
Yes, this is our waivers and affidavits.
Form.
It's filled out by me, but there's something highlighted that I did not do.
And was that form filled out as it relates to Sarah Boone?
We're talking about just this top, right?
I got really excited because when she sat down, she like bent the mic, but didn't bend it down quite far enough.
No.
Yes.
It's a little bit short.
Realize where her
a little
mouth
bit
is.
short.
Yes.
Did you see her sign it?
Yes.
Is that your signature below?
Yes.
Fortunately, the captions are
And
pretty
is
good.
that the consent for the phone?
The consent to search, yes.
Till there.
Is there also the wording?
Now he's going back to the consent to search.
That is a form that's standardized by the sheriff's department.
Yes.
And you did not read the Miranda.
Sarah Boone. Get on that.
From this piece
Phil.
of paper,
Yes.
that's
I wanna
audio
see
being
that.
recorded, no.
You would agree that
This detective, she's crushing the Farrah Fawcett hair game now. Get that feathered thing. Baby, you gonna do that feathered thing? Dude, no one can hear you, jerk off.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave
Yep.
a statement to the detectives.
Right.
And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances. of
Well,
the
you're just going to have to
voluntary
wait till the motion's over so he can deny it.
response. Judge.
This is a totality of
obviously we
circumstances.
disagree, you know,
Well, then where's the case that supports that? Because
Yes,
as
sir.
I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney, before and after questioning. If you can't afford one, one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement,
But you didn't
there
tell the
must be a
judge.
conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those four, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of
Why not?
the decisions in Thomas 351, 7th, 3rd,
You
197,
lost.
Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether sufficient Miranda waiver was given.
It's
Do you
whether
agree,
she waived.
Detective, that after you read
That's a
her
$1 million question. Did
those
fucking waive?
Miranda rights,
Uh-oh. Long crime froze up. That's not me. I didn't do it. I didn't do it. Oh shit. Damn.
What?
Like long crime just like disappeared off the face of the earth.
Well, go back to the other one.
Well, let's see. Wow. Okay. Boop. We can't block the thing up there though. That's the problem.
I don't know what to tell you.
I know.
I know how to help you.
We have to have like when you go on with Melanie, does she use
Anything else?
StreamYard?
no other argument, Judge.
I don't remember. I don't pay attention.
Anything further?
Same argument.
All right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as states 1. I'm sorry, defense is 1.
Oh, what?
I'm sure live trial TV has no problem with us using it. Yeah, I know. See, like, I can't figure out. Oh, who did that? Who got that guy there?
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
This is a risky proposition. There
previously
is
sworn at the
no
beginning.
point. Wait, what? Was that a hot mic thing?
Oh, so
Rewind that.
there. That's good enough.
Wait, rewind it.
Yes,
What
sir.
did he say?
Wait, what?
What did he say?
Hang on, the deputy's got a mover.
He told Sarah he hated her haircut.
Oh,
And Miss Boone, I just want to state on the record, your haircut is ridiculous, ma'am.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Oh boy.
Ms. Boone can approach the podium.
Wait, didn't he just rule?
She was previously sworn at the beginning.
oh, okay. It was just the judge. Sorry, Bob. Where are you?
What I keep doing.
I don't
So
know.
weird. It's like I'm just touching the pad. Like, and something keeps happening when I have two fingers on the pad.
Yeah, that's how I got booted out like that too as well.
I don't know what it is. It's like the Mac. It's like if I use two fingers to swipe down, it's like shutting the whole fucking. It's like cutting me out. Weird. Oh, tech. So fun. Hey,
Ma'am, you've already been sworn. Counselor, you may proceed.
Just use a bigger top.
At least
thingy.
I don't call videos on a phone videotapes. At least I have that. I'll always have that.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
I'm confused. Didn't he rule?
He just ruled. Basically, he ruled.
Where are you currently housed?
At the Orange County Corrections Department.
Well, he definitely ruled.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
Why are you screaming?
Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
My eardrum's
Yes.
out.
Still?
Mine, I can turn it down.
What mental state did you have at that time?
What?
I was very confused. It was very hazy. I
It was hazy.
didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations
so.
that her statement was involuntary because of her mental state or state of
Yeah.
intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it.
Okay.
Objection sustained and it's stricken.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay, how long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation.
Objection. Yeah, sustained.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay.
That's better.
Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
Objection, sustained.
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesell.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
Magic?
It was with a passcode.
Okay.
Oh, or that.
And when you unlocked it, did you give it back to the detective?
I did.
Why?
Did you ever see the phone again? Okay. After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her
her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
All that normal protocol shit?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes,
All right.
Did you waive those rights?
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No,
Did they ever indicate to you that you were a person of interest?
no,
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
I don't know how this is helpful.
All right, after they finished interviewing you in the unmarked vehicle,
You've been much more
were you
helpful
allowed to get out?
if she had been.
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time,
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Kopsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
Did you call for a yes or no? She said yes, and now I don't know like what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Copsell was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
They've agreed
And
that this
was
is
he-
custody.
What was he wearing?
I don't know.
Oh,
He was wearing
my
a
God.
red shirt along with his firearm and black
Can the
pants
state
His
of
firearm
fact,
was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator, where did you go from there?
He brought me into a very small room.
my Lord.
And they had me sit down, and then from there, I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes.
correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
I can't find that little objection soundtrack.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Awesome.
Sustained.
I felt good.
Were you trying to comply with the officer's demands?
Overruled.
How's that not
In every
relevant?
way.
What the fuck are they talking about right
Were
now?
you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
But you testified earlier.
Is that what she had said the day before?
No,
What do you mean?
Normal protocol.
Yes.
Had she,
it's not what she
had she
testified
said
to
the
earlier.
same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
Am I crazy? She did not. Said no on.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read Having these rights in mind, do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
Are you
No further questions. Thank you for wasting all of our time.
And on a medium low note, buddy.
The way that she acted, the things that she said.
All right. There was
The
no
fact that they
coercion.
had your phone.
She wasn't free to
Did you
leave.
get, did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
That's
She was
not.
in custody?
Jesus
That's been
Christ, dude,
conceded.
they said it fucking 50 times. They're conceding that she was in custody. What?
That's what I'm.
Well, I'm going to tell you what's going to happen right now. Sarah Boone's going to look at the judge and says,
He's
"Judge,
fired.
I hate to do it. I hate to do it. I got to fire this guy." Right here on the
By the
stand.
state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective
What in the
perception
filth?
matter?
Well,
It's almost worse. What,
under the
will you stop saying
circumstances,
that?
it would
Stop
matter.
saying it.
I mean,
No.
she didn't feel she was free to leave. She was in an enclosed small space.
They're agreeing.
She was
That all
They're
goes
not
to whether or not-
understanding it.
Let me finish. She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
Subjectivity matter
No, subjectivity does.
under the case law.
that.
based on the circumstances that she was dealing with at the
Yeah.
time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
Right. It's a
I
reason.
believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Right.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
No, how's that? That shouldn't have been sustained.
Ma'am, that day,
Well, I guess it's a reasonable person.
you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
You don't even need to.
Gonna take that shot.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
Oh boy. And then you lied.
As much as impaired means, it did affect, yes.
Okay.
Why is it
And
an
that
objection?
was consumption from the night before,
Please
correct?
object.
Yes.
Object.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Fucking- I cannot believe
And you
this.
consumed no alcohol in your home that morning, correct?
Oh my God.
So
What is
does that
happening?
affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then,
Did alcohol affect my conversation with her?
No.
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
No.
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Objection.
Judge, I think she said she didn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
Relevance. You ruled this out.
I know that she
Relevance.
had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
What did he say?
And you
I don't
understand
know.
that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
He's just making sure she knows.
Okay.
No.
And it is
You know that
your
we-
desire to have these statements excluded from the jury's consideration, correct?
Judge.
Objection.
Sustain the objection.
Come the fuck on.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Objection.
Regarding the
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1. And therefore, she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out.
Statements to cops is not testimony.
Out so that she is not going to be cross-examined, impeached with it so that she can
But she
testify
can be
the way that she testified this
Can the
afternoon.
lawyer respond with that?
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be
What?
biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail, meeting with the state's expert who evaluated Sarah Boone. I was present. The 2 prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to.
Ted Cruz just gave him the high sign. The anything further, he's like, sit down, dude. I'm about to rule in your favor.
I mean, he's
Accept that answer. There's no way for me to extrinsically
pause.
impeach her with that due to the brevity.
He is only using this to get her on record for any other possible
Trial.
thing.
For
Right.
trial. He's bringing all this shit up. It's like,
But what I keep trying to say is, so let's say that I, make some sort of confession and then that confession gets excluded. And then I take the stand and I testify in direct opposition of that statement. I
Comes
can
in.
still be impeached with it.
right.
So his argument in that regard is legally and factually flawed. And that's sorry, and that should be the argument that the defense attorney is making right now. And he should have definitely objected to I don't know why he put her on the stand when he had no chance of winning.
No chance. It
It
was
was just
fucking
not worth it.
insane.
It was like, you know what? You get to that point and then you say, hey, this judge has told us in no uncertain terms.
He's ruled
And no,
twice.
he has freaking ruled for all
Ruled.
intents and
2
purposes.
times. 2
And
times.
it is not worth us putting you on the stand. I'm
Right.
shocked. I'm just
Now,
shocked.
all that drinking shit, because her entire the beginning of the entire interrogation, the
Right, she's
longest
saying she
one,
wasn't drunk.
wasn't drunk. I wasn't drunk. I wasn't drunk. And so it's like,
Well, she's already.
Of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
No.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Objection.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to council's table.
Are we done so I can do
While she's in the process of returning to council's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
oh, y'all. Crank down that sound booster a little bit.
Mr. Owens, it's your motion, sir. You may proceed.
Judge, it's clear that my client was in custody.
If he argues that she was in custody, I'm going to reach through the screen and sock him
Well,
right in the
he
nose.
can argue it on the first one. It sounds like the police car. Front seat. Front seat.
Yeah, it was a terrible, terrible mistake to put her on.
Which my understanding of the law regarding Miranda, first issue was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact.
I don't know about
We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video.
which we watched, y'all.
And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances.
Wait, what did he say?
He said.
Judge, law enforcement, after they get a valid waiver of rights,
I wouldn't be.
that I'm not going to be silent, that I'm going to answer questions. Go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions.
Bless you.
That they can later use at trial to impeach the defendant and convict him.
Closing arguments.
Wow.
The law allows law enforcement at that stage to use deception,
Accurate descriptors.
to lie. to trick. We found the murder weapon. It's got your DNA on it.
Trick.
Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt.
That's right.
But prior to Miranda, you cannot deceive.
Oh.
Prior to Miranda, you cannot trick.
What? Since when?
That
Find that, babe. Find that case.
right is fundamental.
It's fundamental.
No tricking.
Before Miranda.
You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand.
That's not right. I feel bad now.
I got to read your rights.
Wait, what do you feel bad about?
And you have a right to remain silent.
Huh?
Mocking this
But
guy.
within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it.
After it.
Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses.
I believe Sarah on that. I think the
A
cops.
traumatic event. She lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that
she never actually waived.
she came down under false pretenses.
None of that's helping you.
Coupled with the fact she doesn't have the ninth question.
I'm gonna just start throwing things.
If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority, Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Kupsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent.
Oh shit, I gotta go.
With the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now.
Bob left.
But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Coercive.
Any response?
The judge is
The United
basically
States
saying,
Supreme Court
you
has
don't
said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kupsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kupsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kupsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, for the record, there's 2 exhibits that I tried to introduce. They will be admitted into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Judge, no clarification, but she's here today and she's in handcuffs, so she has difficulty writing.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other two lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf.
The chain gang.
But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. Okay, beliefs.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yes. Yes.
Oh, I wanted to hear that hot mic. That would have been a good hot mic. Hot mic, sheriff in the bench, talking about
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
It's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office tell me they can't do it.
Can you hear me?
Because of the
I can hear you.
concerns that were just outlined.
Hold on.
After she's returned to
What's
the
up?
Orange County
What's
Jail
up, man?
facility.
This thing is still going on right now?
Yeah.
All right. You'll get an
Yeah.
order with regard to
That's
the
order of
restraints no
business
later
there,
than
though.
tomorrow. Moving now to the
Sounds like
state's
they turned
request for
down the,
protective order.
Ram.
I've reviewed that. I need I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, and said this would be added to the hearing for. I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing the enlisting the I think it was
It's the third amended witness lists
Our
certain
dog is
people
a,
as witnesses.
professional
Custodian of records,
watch
Orange
sniffer.
County, Office of State Attorney, Domestic Violence Supervisor for
You know
the
who
Office
else
of the
is?
State Attorney, Victim Advocate Supervisor for the Office of the State Attorney, and Misdemeanor
Your
Supervisor
Your
for the Office of the State Attorney. And the
mom.
state is seeking a protective order on the grounds
ya?
that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we
The old
have listed and plan
self-defense.
to
You hear about
introduce
that?
the fact that George Torres
No.
had been arrested, I think,
Yeah.
3 or 4 times prior to this event.
I mean,
And
I
I
know
think
he
on
was in
3
the
of those
back.
cases.
the defense is going to
the
be, I
case
was afraid to
dismissed
unzip him.
Against
He was going to kill me.
Mr. Torres.
Wow.
And it's going to come out that Sarah Boone
It's a
had
new one.
requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of jail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their requests, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a
if it comes out,
decision.
if it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we're moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
This guy sounds like that little gay
You have a written
gentleman.
order on the motion
He
to
was
protect the orders
famous,
for
little
tomorrow,
short
as by
guy. I think
tomorrow
he
as
passed
well.
away.
Anything else, state? we need to
Anyone know
address?
who I'm talking about?
Was he
Appears,
an actor?
again, been
He was in, like,
conducting
I think he
motions all
was an actor,
afternoon.
but he was, like,
It
on
appears that we are
TikToks.
set to
What the hell is his name?
allow the defense to depose our battered spouse syndrome
Richard
expert at 10
Simmons?
a.m. tomorrow. That will be done virtually.
No, Leslie.
With
I think his name is
regard
Leslie
to
something. He had
the
gray hair,
deposition of
just like
Dr.
this guy.
Oh,
The deadline
I
is
know what you're
tomorrow.
talking
That's
about.
set at
Yeah.
3 p.m.
Okay, that's still set at 3
His name
p.m.
is
Yes,
Leslie. I
there
can't
will likely
remember
be
his
a
name.
Leslie
first.
Jordan. I
Strike
think
if
that might
the
Irene's
form
got
is
it.
I
duplicative.
think that's him.
Dr. Harper's, my understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
What? That's
All right.
outrageous, sir.
Judge, and then on Dr. Brannan's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10. Paul's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brandon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. If go ahead, I'm sorry.
Those two things are the only two things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday.
Favor him a
So
copy,
that he has
Jay.
the opportunity to review that score sheet with Ms. Boone.
I'll do
in
it.
advance.
I'll favor him.
What a guy. What
We're
a
going to be
guy.
filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed.
Oh, hell
Just
yeah.
waiting to see now how the depositions pan out
Well,
tomorrow.
favor
based
him a
on what we
copy.
Witnessed this afternoon.
And favor me a copy as well. Give out all the
Okay. All
favors.
right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all.
Is Monday jury
Which would
selection?
include Mr.
Yeah.
Owens, your
Wow.
opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel.
Grade her
of 50,
lawyer a note real quick.
once we deal with all the cost challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess.
right.
Thank you.
That's it. That's it. That's all. That's all they got. That's all they got. So,
So how was this dude?
He was not great. He was not great. He was, I mean, it was a stinker motion anyway. I mean, the judge essentially ruled in the first 5 minutes telling him, look, like it's not in the case law in Florida with regard to them having to read the language about waiving for Miranda. It's like he gave the ruling. He hasn't ruled. He's taken under advisement. He's going to rule in writing, I think. But yeah. But so the weird things are they're coming forward with the this self-defense and battered spouse syndrome. So like the concept of a self-defense defense basically being that she was afraid to unzip him because he was going to kill her. Like that's what it has to be, right?
Those videos seem to indicate that she didn't.
She didn't
she's
sound real
yelling at
afraid.
him.
Yeah, she's like, ah. She's like, that's my name. Don't wear it out.
Yeah,
So what's going on, dude? What's good?
nothing. How are you? How was England?
It was awesome, man. It was awesome. It was it's just a great city, man. Like there's nothing like it here in the States. It's like nothing even close, really. It's like I could live there. It's really expensive though. It's a very expensive country. Like food's expensive. Like the dollar doesn't have the value. I think it's like the exchange rate was like a buck 26 to every pound. So it was like you have to consider that, like, for a couple $100, it adds up. It's like an extra 10, 15, $20, depending on what.
Did you meet any of folks from like who follow the pod or like people at the crime?
Yeah.
Nice.
Yeah. It was great. I got to do the thing with Hanson. That was
Yeah.
good.
How was that?
It was good. It was good.
Awesome.
It was really good. Like we had a nice crowd in there because we weren't in the biggest room. We were kind of one of the two side rooms, but we had a great crowd in there, very interactive. Chris was great. He was great. And it was funny kind of going in because we had one Zoom with one another and like kind of landed on what we were going to talk about, but we didn't really kind of go through like how we were going to do it. Like, did he want me asking him questions? Were we like flipping the script where like I'm the interviewer and he's the interviewee? but it worked out. So yeah, it was great, man. So how's work, dude?
It's
Work?
work, you know. It's
Yeah.
it pays the bills.
Yeah.
It's everyone there is very very nice. But you know, I'd rather be doing this. But what are you gonna do?
What are you gonna do?
I gotta tell a funny story, and I posted this to Twitter. But Bob, I don't think you've seen it yet, so no one spoil this for Bob. So I am an affiliate link. I do the affiliate thing. By the way, I have so many fucking. I have to make 53 videos because people. I hit on one, Bob. I sold some fucking rain jacket for the company that made this hoodie. It's called and 130. It has 150,000 views or 100. So now I have like good numbers. So
Yeah.
people keep sending me shit, and like you could not accept it, but I'm like I'm gonna take all the free shit I can get. I have like 1,000 hard drive. I got some good stuff. Like I got a chainsaw. I got like this fucking thing. Like people are just sending me shit. I got like navigation for my. I got so much shit. But anyway, the funny thing is, I get this thing, and a lot of it. First of all, these people that talk to me, they're not English speaking, and they use typically they seem to be they want WhatsApp, and they send me messages that are like, hey honey, hey dear. Like it's weird the way they talk to me.
Right.
Like
they're trying to sound American. But
yes, they're trying to sound American. So I got this thing today, and this is what it's. I don't know if I could. Let's see if you guys can. Can you read it? I'll read it for you. Backpack elderly decoration. I'm like, what the fuck is backpack elderly decoration? So I'm going to show you guys.
Fascinating.
It's really actually a cool thing, but it's hilarious that this is what they call this thing. This is the elderly and his backpack. It's a Santa thing that they refer to as backpack elderly decoration. I thought that was hilarious.
That thing's awesome.
It's
That's
great.
awesome.
So yeah, I'm gonna post a video. I have 53 fucking videos to make. The hope is they go viral, but they probably. The only thing that went wrong was the rain. I'm like Morty Seinfeld. There was a rain jacket, and it has 160,000 views, and like 130 something people bought it. Made the company.
I gotta see what I haven't watched that. I gotta watch that.
It's not even like a great video, but like you never know on TikTok what's gonna hit. And then like people are sending me shit, like so much shit. I have 50.
I know, dude. It's like I haven't accepted anything yet. Like I've got because I joined it too, and it's like I'm afraid to join it because it's like then I have to make the videos.
Yeah,
you know what I mean.
It takes me a while, or you can go live, which I've yet to do, but it takes a while to make some of these videos. I just had one made for Babe because they sent like a bag, like a I don't know, she uses it for like a pocketbook. I got across the body bag. I got a fucking vase. The other day, I'm like, what is this? I was like, oh shit, that's right. Someone offered me a vase. So I have to make a video for a fucking vase. Babe has not used the pillow yet. I got a one of those side sleeping pillows. I told her to use it. She hasn't used it yet. I
keep getting shit for translators, like where.
I made one for that. I was like, I don't know how to use this thing. I made a terrible video, and the beautiful thing is, if I don't like the product, you have an option to only post it for if they want to use it for ads, so it doesn't show up on my TikTok. So if you guys if I get something shitty, you'll never see it because I only do it as an option for only in ads. Oh, someone's a funny story, Bob. So you probably haven't seen this video. I get a thing, and it looks like it's for a supplement. It's just listing. It says Men's Health because I get vitamins. It's Men's Health, and it just has like it's made by like all the ingredients. I'm like, all right, I'll take a Men's Health. It's a multivitamin. I get the fucking thing in the mail. Here it is.
Sperm health.
Prego.
Sperm
health.
But he's got some sperm health. You got to come up with little jingles for all these things, man. Like if I decide to do this, I'm just gonna do fucked up jingles for all of them.
You should.
Yeah. I mean, people love it.
I sent a message to my guys. You sent the wrong thing. I wanted a multivitamin, not freaking sperm health, because I got the snip snap, so it doesn't fucking matter to me. And they're like, no, we had to rename it that because you can't like promote on TikTok sperm health. So now, if anyone wants, some powerful sperm, I'll send this to them. I don't. Our demographic is majority of ladies. I know that, but if you have a man in your life that wants some sperm count and motility, just let me know and I'll send it.
All right, hold on. I'm trying to find your. I want to find your.
It's pinned. It's on the top of my TikTok.
Oh, it is. Okay, hold on. Wait, so this is the amazing, some kind of like, this looks like a satchel. Wait,
No, that's the last. That's the one I did.
okay. Like TikTok looks different now. Now I've got like, what the fuck?
It's one of my 3 top pinned.
Hold on.
videos.
Oh, okay. Here. Oh, there it is. There it is. The packable rain jacket.
I say whole ass raincoat. I don't know why, but
That fits in this tiny little pouch.
Wow.
Take it out here.
I don't know why. I don't know why this is the only video that like hit, but it has 160,000.
It's lightweight, breathable, windproof, waterproof. It's great.
Great.
Fandy, the company that makes this, is headed to Fashion Week. So
I made the company like $2,500.
That's awesome.
So now because of that video, that's why people send me shit. I think.
I got you. This is a raincoat that fits in this tiny little. Take it out here.
I tell you, I'm
Look
like
at that.
Kramer and Morty
Dude, that's some
Seinfeld.
championship quality shit right there, bro.
I'm like Kramer and Morty Seinfeld, just slinging rain jackets.
Oh man. So yeah, I mean, keep selling that shit. Like,
I'm-
so
I-
what, do they pay you? Like, do we
I
get
get
paid?
commission. I got
Okay.
commission. So
All
I
right.
made I could check. But the way I look at it is if they're gonna send me free
Free
sh-
shit plus
I'm gonna take
whatever
it.
you did. Yeah, no doubt.
Exactly.
No doubt.
So yeah, I made like a few $100 just by selling that stupid raincoat.
That's
So,
awesome. That's
that's
pretty
the way.
sweet, man.
But Patty B has a question here. Were the statements suppressed, Bob? I don't know the answer to that.
Yes, they will be. The judge did not rule from the bench. The judge is going to, it sounds like, put it in writing. So he took it under advisement, but it sounds like they are not going to be suppressed. Defense is going to lose that motion, and these statements will come in, the videos will come in. And then you missed it, Jay. Like, they put her on the stand.
How was that?
Dude, like, you shouldn't have done it. I don't know why he did it. Like, if he would have been paying any attention to the hearing, the judge had ruled like 2 times. He had said, well, Florida law doesn't support what you're arguing here. It's like the whole Miranda thing. Like, she was read Miranda, and there is no case law in Florida relative to the waiver issue that you're talking about. They don't need to read that portion of it. They just need to read her rights. That's it. So you're fucked. And then he said that twice, essentially, and then he still put her on the stand. And all the state's attorney was asking her about was whether or not she was drunk. So, like, they're going to completely impeach her now with that testimony, sworn testimony, how she was lying to the police that she wasn't drunk, because in the beginning of that video, she was denying it completely. And then at the end, she kind of like says, well, I guess I was more drunk than I thought. I had only drank a bottle of wine. So, but remember, man, she excels at everything. So she'll figure it out.
I'm sure she will.
She'll figure it out.
So do you have Delphi coming up too? Like, this starts next week, and then when does Delphi start?
Jury selection starts the 14th, that Monday. So 2 days. I don't know if I'm going to do jury selection. I might skip that, but we'll see, because it's like very limited seating for jury
I saw that. I
selection.
think I Sleuthy or somebody saw posted. There's only like not a lot of room in there.
No,
See.
and it's same with the courthouse. It's going to be, they're going out for blood. It's like they gave 12 seats to traditional media. So that means, like, she doesn't consider any of us YouTubers or podcasters to be, actual media, which is ridiculous. It's where everyone gets their news these days. No one watches any like traditional legacy media to get their fucking news unless they want some like slanted bullshit.
So is this gonna be like a Karen Reed situation where you have to like set up a chair and get there super early to like get a seat in there?
It's what I always have to do. Like, every time I go there, like, the thought of the concept of doing that for like a month is horrifying. And she's talking about going from 9 till 6.
Oh,
yeah. I'm having like instead of post, it's like pre. It's like I'm very distressed. I'm very distressed about it. It's
I bet, because then if you're doing it 9 to 6, how are you? Then you got to do a live, and then do it again. That is gonna kill you, dude.
I know, dude. I know. It's brutal. It's brutal. Yeah, probably like an hour for lunch. But yeah, 6 o'clock and like I cannot speak to just how uncomfortable the seating in that courthouse is. It's all like old. It's all the
I
original
saw the
like,
picture. Yeah,
chairs,
man,
dude.
that is gonna be. Can you bring like a little cushion to sit on?
I'm going to like people were like
Oh, good.
I have like this thing that I'd like to bring. It's like I bring it to Scarlett's volleyball games.
The little seat thing that you put on. Yeah.
Yeah, they're great. They're great. They're pretty comfy. Yeah, so I'm not looking forward to it. I'm not gonna lie. Like I'm gonna be putting in the work on that thing. So, but you know, I'm knee deep. I can't back out now. I can't back out when it matters most, right? I gotta go in, fight the fight, be in pain. Like the biggest thing I want is somebody who will take notes for me, like that's in there, so that I can observe the trial. Because like when you're taking notes, or it's just constant like note
Right.
writing, and you're not looking up. You're looking at your like I can't do it. I can't write without looking at my pad of paper. It's just
Right.
facts.
Do
It's
you know
facts.
anyone that's like gonna be there that could do that for you?
I had a couple people email me because I was sniveling about it on a live the other night. Anytime I snivel, it usually helps. Like people will reach out and they'll be like, "Oh, I heard you sniveling and whining about having to write the whole time. Like I could take notes." But it's going to be super competitive to get in there. Like I know Andrea Burkhart's coming, and she hasn't really even covered the case. But I was messaging with her. I'm like, like this is like a 5 a.m. line fucking nightmare thing.
Oh my leg.
Yeah. It's it's that thing because there's so few seats. So I don't know, man.
And you can't bring it you can't bring anything to record it, right? You can't have anything in there, right?
Nope.
Not your watch, not your phone, right?
Nothing.
Oh.
Nothing. Yeah.
Oh.
Yeah. So like you're completely off the grid, like the whole time in there. So no, like even live tweeting, can't even live tweet. It's crazy. It's like archaic shit, man. But what are you gonna do? What are you gonna do? It's gonna be a fascinating trial, though. That's for sure.
Yeah.
It's a shame it's not gonna be broadcast. Because that thing would like people that don't know the case, like it would blow Karen Reed away. It's way more fascinating. It was way more fascinating.
I
Yeah.
think it's a little late for Bob to take a shorthand course.
Yeah. Yeah. It's
Well,
like,
maybe not.
I don't think it would take. So yeah, I don't know. So the Mets, man, how you feel? Like good game yesterday. You guys took
Yeah,
that for
like
are
I
they
almost
playing today too? Or is
yeah,
there a day off?
7:30. And Babe right now is watching. What's the Royals? What's the score? Oh, and what inning? The Royals are up. The Royals won their first game. Babe is from Kansas.
Yeah.
The Royals won their first game, and they're up 1-0. So the last time both the Mets and Royals were even in the playoffs was when me and Babe met. So
So who
yeah.
What is the score? What inning is that?
1-0 Royals in the fourth inning right now.
Wow, they're getting some pitching. I mean, if they win today, it's done. They advance.
Yeah.
Shoo! Same with y'all. Well, I'm rooting for you, man. I have no dog in the hunt, man. I want my boys' team to win. If it makes you happy, it makes me happy.
Well,
You know
I
what mean?
appreciate that. And your guys actually beat
Set the
my
record.
Mets. Beat them the 1960. I never thought the 1962 Mets
Yeah.
record.
Yeah, worst team of all time. What a like. I mean, if you're gonna go all in, go all in. Be the worst. Don't just be like really, really bad.
Right, don't half-ass it.
Right, just be the worst of all time. So yeah, it's brutal. Hey, what's up? Oh,
Hey,
hey,
how was England?
This is Peyton.
Hey, we got the whole little volleyball crew
Oh,
here.
got a little crew in there.
Wow. Yeah, I mean, I'm live. Wow. How was England? Did you have fun?
What was your favorite part?
The Buckingham Palace.
You like that more than Stranger
Or the
Things?
play.
Stranger Things was pretty awesome.
Oh, you saw a play. That's cool.
You guys try to find a snack, see what you can find. Fruit snacks. Yeah, dude. We went to go see Stranger Things, and it was like unbelievable.
Yeah.
It was like a 3-hour play.
Oh
and it
my
was
god.
so like Leicester Square is like really what Broadway is based after. You know, it's like based on it, except it's like way more beautiful. You know, there's no like bums. There's no people sleeping in the street. There's no like cowboy in underwear singing and shit like that. You know, we went, it was at the Phoenix, Charlotte. It's a great theater, but dude, the special effects on this play like blew my mind. It felt like you were watching a movie, man.
Wow.
Like when you'd go in the upside down, they had it, dude, it was insane. It was like no play I've ever seen. It was amazing. 3 hours long though. But it
Was there a break?
yeah, but it was
I
only
was gonna
15
say.
minutes and
15 minutes?
everybody had to piss. So
Yeah,
it was
that's
like,
my thought immediately.
yeah, like and the line was huge and they only had like one or two like stalls in each bathroom. So I ran across the street and like there, public bathrooms are not a thing. Like you have to be a customer. They have the doors locked typically, but the usher that was taking the ticket taker was like, "Hey, if you go across the street into that bookstore on the 5th floor, you can get like." So I ran over there with Allie and we took the lift up and we went and did our business and made it back. And it was like just in time for the play to start. So it took the entire time. It was a great trip, man. It was like I looked at my so I kept track of how much walking. We walked 43 miles
Holy shit.
in 5 days.
Wow.
So, yeah, dude, it was a lot of walking. It was a lot of walking. Cause that in earnest, cause like the days for Crime Con, there was some walking. Well, it was probably the full 8 days, but the bulk of it was the last 5 days. But yeah, man, and the system, like the public transportation system's amazing. It's like so like I hate buses, but like there I love the buses. Like the buses were an amazing way to see the city, because it's like you pass by Parliament and like just it was great, man. Great trip. Great,
That's
great trip.
awesome.
I highly recommend it. I highly recommend it. There's just like the London Tower was cool as shit. Just like the history of it and just it looks amazing. And it's like you get so many like amazing shots of like kind of the old and the new, like where you can have like a shot where you've got like large kind of like portions of the tower, which was really they used it as multiple things. It's now where they house the crown jewels, but it was used as a prison, it was used as a fortress, so it was like, and it was just cool, you put on the headphones because I didn't want to follow the dude around. I wanted to be able to kind of like walk around and check it all out. But it's really cool. It was a really great
How was
trip.
the food?
Like I didn't get to really eat like I ate like you would eat, man, because I had the girls. Like none of my Allie and the girls are not foodies. They like fucking tendies and like the same shit you like mac and cheese. So I had the fish and chips were great, like super fresh, cod, like big piece of fish, and then you get the French fries, and that was great. So I didn't really get to go and have like a killer meal, because like the kids were not feeling it. So, but I had some great Indian food because there's a ton of great Indian restaurants out there, and it's like and there was another spot that I had like there was one place I took Scout because we split up because Allison found some pasta place. She wanted to go eat this fucking pasta. Like all I heard about was the pasta. I'm like, it's a fucking noodle with some like arrabbiata on it. Relax. Like it wasn't that. I'm like, I tried to bite. It was okay. It was like, but why are you raving about it? Like it's the greatest thing of all time. And so we split ways, and like I found some kind of like pancake place, and there was like it's kind of a savory pancake dish that was pretty good. Yeah, the Indian food out there is like amazing because it's truly a melting pot. Like it really is. Like culturally, you have like so many different cultures. It's just a whole different vibe than the States, man. It's like it's great. It's a great place. Like I
Nice.
definitely I could live there, but it's super expensive to live there. But I just had like just a blast. I wish I had like 2 weeks because I would have gone up to Scotland definitely, and I would have loved to have been able to hit Ireland as well. But yeah, it was good. It was great, man. Great trip.
Nice. Awesome.
Yep. So it was the jet lags for real though. like going there. Like it really took us a long time to like kind of get adjusted to it, but it was intense because for us it was uh a 7 hour time difference, and like so when we got over there, they always say try to stay awake, because I couldn't sleep on the plane. I tried. I was like, oh my God, I wish I could just sleep. Because we took us like a 6:15 p.m. flight out of Chicago. And when we landed in London, it was like 8:45, 9 o'clock in the
Mm.
morning. So it was like we had the full day, and it's like I wasn't confident with like traversing like the public transportation at that point. So I took an Uber and it's 21 miles from Heathrow to like London, downtown London. So it took like take a guess how long it took to get 21 miles from the airport to our hotel.
2 hours.
2 hours 45 minutes, man.
Oh,
It was brutal, dude. It was it was the worst. It was like,
that is after a long flight.
oh
Oh,
man, yeah, exactly. After that long ass flight, and then I had gotten like an Uber, and I didn't even know if they had Uber over there. They don't have Lyft, but they had Uber. And like I ended up getting a super small car, so I didn't know if we are going to be able to fit our bags in. So yeah, it was. But aside from that, so I was just taking public transportation for everything after that because it's so easy. It's just the tube and the buses. It's like boop boop, and they run constantly. You're never waiting for more than like 5 minutes, really. So it was awesome. It was an awesome trip.
nice.
Really was. Coming back though, I didn't really have the lag, but I've been going to sleep way earlier, which is good. Like the
Right.
girls were all like going to sleep at 9. Like our first night back, like I woke up at 5 in the morning because I probably went to bed at like 9. And I hear like Cameron, she's down the hall. I'm like, "Are you up?" She's like, "Yeah, I woke up at 5." And then Scout texts me. She's like, "I'm up. I woke up at 5." And that was like on a Saturday, So we were
Right.
like, "What?" But yeah, no, it was awesome, dude. We had fun. It was
Awesome.
good
Awesome.
times.
Awesome.
It's good times. So yeah, that's it, man. I miss you, dude. I
Miss
really
you
do.
too.
Miss you so much, man. What do you got going on? Anything I need to portal people to?
No, I've just been lately. I've just been doing rewatches of
Short?
Charlie, but I got the playoffs tonight, baby. So I might do it maybe on Friday or this weekend, depending on. There's a game tonight, and then they win. Then we got the Phillies, but I don't want to get ahead of myself. I don't want to.
Ooh,
I
man.
could very easily lose the next two. It's the Mets, so
It'll be that would be a brawl. You guys in the Phillies would be
yeah.
something, man. Well, I'm rooting for you. I'm rooting for you. If you set something up, text me. I'll portal everybody over because I'm gonna
Thank you.
probably be doing some kind of live. I haven't figured out what I'm gonna do tomorrow. Hopefully Tracy. I'll go into Seeking Justice, see what's up on the docket if there's anything interesting. Like, did you see this? Like this case with the? I know you're out of the kind of the scene right now, but like there's this sheriff who shot this judge.
Oh my God, I did it, and apparently the judge was like allegedly having some relations with his daughter, right? And he has his daughter's and
That's
how old is his daughter? His daughter, the sheriff's daughter is like a minor, right?
yeah, that's what kind of like it sounds like, man. So I don't know, but I'm gonna probably put together a live for that because that one really piqued my interest. It's a fucked up case, man. But yeah, because I didn't know any of the backstory. And then he was up in court today. I think it was today. It might have been yesterday.
Yesterday, I saw when they showed the freaking video. Holy shit,
Man, dude. Like just putting the dude down, like right there.
I mean, it
Yeah,
sounds
like
like
it had something to do with the phones, right? Like that was the whole thing.
yeah.
He's like,
Apparently, I mean, I don't know that, but like apparently the sheriff was trying to use the judge's phone to call the sheriff's daughter, like at the like or something like that. And I mean, this is like a Gary Plowshake, right? I mean, this is a potentially,
if that's what it is, right? Yeah.
potentially a case where he might not get. I mean, I don't know. Obviously, it's very early, but for I had Jody on my show. I know Steve has had him on his show, but like, his dad didn't do any time. I mean, he
I know. It's like, yeah. Like Chris has him on his shit. Like used to have him on his shit all the time, didn't he?
Yeah,
Like,
yeah,
yeah,
Chris. That's how Chris introduced him to Chris introduced him to me, and I know.
yeah.
Poor Steve, by the way. You saw Steve like he has like no
I know.
power,
He gave
dude.
you love. He said you sent battery packs to him, so he was
Yeah.
very thankful for that and gave you a shout out here on the stream. So that was yeah, like I knew that they were like they didn't get the flood, but I knew that they were out of power. I didn't know they were still out. Like Steve was in here today, so they're going through it. Like we've got like a couple of really close friends that live in Asheville, and that fucking town is like destroyed. Like
Well,
it's
it's wild.
brutal.
Everyone thought it was gonna be Florida, which I mean, I'm sure they have, but these places that you wouldn't expect to be destroyed by a hurricane got this like you see some of these houses, and it's not like they're by the water, and
Yeah.
some of these houses are going on are just floating in a river.
A ton of them were like in the mountains,
Yeah,
and they were like,
exactly. Not, but I say the water, I mean like not by the
yeah,
ocean, but
right. And it was like, dude, they were talking about it looked like islands. So like you have to imagine just like the mountain peaks, like and everything else was underwater.
it's
Like
insane.
it's insane, man. It's like it's devastating. So I like it's brutal. It's brutal. Yeah, our love goes out to all those affected for sure, man. It's
Yeah.
brutal. It's absolutely brutal. All right. I think I'm gonna wrap it. I miss you, dude.
Miss you too,
Go
dude.
Mets. Let's fucking go. Let's go
Thanks.
Mets. Let's do it. I'll text you, of course, during the game. Not
All
too
right,
much
sounds good.
because I know that you're like me. You're like freaking out on every pitch.
Oh,
And
it's yeah. The
especially
playoffs is like another. It's exactly every
every
pitch,
pitch. Every pitch. There's no sport like it. It's like it. There's like the closest is hockey. Like playoff hockey is pretty intense. But if you've got like a 1-0, 2-1 game in a playoff baseball game, dude, there's nothing more intense than that. Every single pitch is like the end of the world, man. It's so I feel your pain. I'm glad you're going through it. It's like it's you wouldn't have it any other way,
True.
despite the fact that it's like torture.
True.
It's like enjoyable torture though. So all right, let me give some shout outs.
All right, dude. Thanks for having me on. Thanks, everyone.
I
Take
love
care.
you, man.
Love you, dude.
Say hi to Hugs the Shans.
All right, we'll do. Bye.
All right, so real quick before we dip, Nav the Theo, you're just an absolute hero. That 50, like that's like always with the 50, it just always blows my mind. We're so thankful. Thank you so much for that generosity. I don't even know if you're still here, but if you are, this is for you. Yes. That's amazing. And then Dawn, always give her another one with 5 gifted DD memberships. So we appreciate you so much, Dawn, for everything always. Chrissy M with the $5 holla. Appreciate you so much. We really do. Meg, always give a can't forget tip the Bob Tender. That's wonderful. Thank you so much. Dawn, she usually sends me supers when I'm muted. So I appreciate you so much, Dawn. Thank you so much. I threw out 5 to the crowd. And then Sean, my boy from over at Potentially Criminal, great channel. Go check them out. Sean's great, super bright guy, another fellow lawyer. He's great. And then finally, last but not least, Joanne, we adore you. Thank you. So you guys keep your notifications on. I'm definitely going to do a live tomorrow. I haven't figured out what it's going to be. Oh, thank you, Charlotte. We love you. We love you so much. I wish I could have seen you when I was in London. If we come back in June for you, CrimeCon UK, I hope you can make it over there. I'm gonna and if you guys are going, I'm gonna give you a reminder. Use our code DEFENSE, all caps. When you buy your tickets, you get a discount, and we get some credit for it too. So, and to my mods, you guys are amazing. Specifically, Mandy, Missy, thank you guys for hanging out with me backstage. Welcome back. Mandy Joe, we've missed you so much. I know you were feeling the love in the chat today. We're so happy you're back with us. You were always here in our hearts and our minds, but we're super glad that you're here in chat because it ups the game, always ups the game in the chat to have you here. So we love you. Afton, thank you so much. Kai, always. Brooklyn, you're the best. Meg, Missy, you guys are just all amazing. CH, Sarah, aspiring. You guys are amazing. Shiraz came in late. Didn't even see you. What's up, girl? All right, you guys. Thank you. Thank you for hanging. Keep an eye out. Make sure you like on the way out. Make sure you share. Make sure you subscribe. Let your friends know. Let your neighbors know. Because without y'all, I am just an old man talking about a shit ton of cases. Talk to you tomorrow's.